Judge, just so that I I want to pursue just a bit about what Justice Charlie has raised about locus. Now, if you read Article 22, yes, 22 of the Constitution is about enforcement, and that is the article that dealt with the locus standi. And it says that every person has a right to institute court proceedings claiming that a right or a fundamental freedom in the Bill of Rights has been denied, violated, or infringed, or is threatened. And more importantly, if you look at 22(2)(a), it says a person acting as a member of or in the interest of a group or class of persons. So I don't know what your view is. If somebody is acting in the interest, then don't they stand at the same pedestal as the main party? So that what Justice Charlie is trying to raise, if you look from the beginning, we had Muma Matemu, which said you just need to demonstrate a stake. Then now you come to Fugicha, Mastermind. Then the latest decision is, I think, the one on Mzima Springs, where the Supreme Court seems to be clawing back that very particular interest that is set out in the Constitution. So then I don't know what your view is, in view of saying that the Supreme Court seems to have taken a conservative stand on those who act in the interest of others, because it's clearly set out in the Constitution.
Okay. Let me attempt to answer that question by looking at the import of Subarticle 2.
Yes.
In addition to the person acting in their own interest, may be instituted by a person acting on behalf of any person who cannot act in their own name.
Yes.
I think that provision, in my reading, is very specific. This might be, for instance, in respect to filing or urging a matter by one person in respect who has been disabled by whatever nature, either because of age or mental capacity or mental state, to bring that in their own name.
Okay.
Secondly, if I could just pursue that, is that there is a place for class action within the architecture of our litigation, so that if someone wants to start a class action, there are procedures in which all those who are interested can mainstream their interests within that litigation. I do not see a contradiction between the position that has been taken by the Supreme Court and the questions of locus standi, because there are other provisions which no doubt have their place in terms of fair hearing. There is a respondent to respond to proceedings in terms of what is it that they have to answer, what is it that there has been pleaded, the case that they have to confront. There are other avenues in which such interested parties could mainstream themselves very early on in the main dispute.
Okay.